On Law Weekly today, we discuss possible reforms to the Constitution and the Electoral Act. We have the views of a senior advocate of Nigeria, Kunle Adegoke. We also have arguments for and against the president's extension of the expired tenure of the Inspector General of Police, Mohammed Adamu, plus our recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shieli. On Tuesday, the 2nd of February, the Senate Ad hoc Committee on the Review of the 1999 Constitution said it had begun the process of compiling suggestions, reviewing and analyzing the reports from the 2014 National Conference, the All Progressives Congress APC Committee on True Federalism, and several other memoranda for the purpose of translating them into various constitution amendment bills for consideration by the Senate. Against the background of this constitution amendment process, I spoke to Senior Advocate of Nigeria, Kunle Rashid Adegoke, to get his views. K-Rad, as he is popularly known, had his first degree and his master's in law at the University of Lagos. He was called to the bar in 2003 and conferred with the prestigious rank of SAN in 2020. An expert in civil and commercial litigation, he has also been counsel in many notable election petitions across Nigeria from 2007 till date. He was a member of President Buhari's legal team at the 2019 Presidential Election Tribunal. And of course, we discussed electoral reforms. But I started the interview first with his views on what areas of the Constitution the National Assembly should consider for amendment.
Fundamental and which concerns every stakeholder as far as Nigeria is concerned as an entity is the legislative lists. If you look at the legislative lists, fundamentally we have basically two. Although there is usually a reference in legal circles to what we call the residual matters, but this is not contained in a particular broad list. It is just what remains, what is not contained. So we have basically the exclusive list and the concurrent list. If you look at these two, the exclusive list is meant for the federal government. The National Assembly alone can legislate on that. In it, we have 68 broad items. In an item, we may have about 2 or 3 items, sub-items. And the implication is that we now have our own federalism, different from the federalisms known to the rest of the world. We have a federalism that has powers concentrated in the federal government at the center. And that makes the craze to get to the center, to control the center, to become really overbearing. And this is not healthy for the system. In the concurrent lists, we have 28 items.
As opposed to 68 on the...
Exactly. Okay. Well, now, when you now look at these 28, they are even meant to be shared between the federal government and the state governments. And where the federal government has legislated on an item in the concurrent list, and has covered the field by the language of the lawyers, the state government cannot legislate.
They have no business on it.
They have no business on it again. So the implication is that the areas of influence of the state governments have become so watered down.
Very limited.
This is exactly very limited. This is contrary to what we had in 1960, 1963 constitutions, where more powers were in the regions, which enabled the regions to, add a kind of economy that could sustain them. That, a little was that the control of the center was fascinating then too. It's not that maybe it became something so useless. We weren't running a confederalism, so they must look into this. There must be more powers devolved to the states. That will enable the states to be better in control. Then we must make sure that the current provision, Section 7 of the Constitution with respect to the existence of the local government is not strong enough. We must be, yes, it is required that there must be a democratically elected local government structure at every point in time. But you see the state government flouting this. They dissolve the local governments at will. We need to strengthen these provisions that will become practically impossible for a state governor to just wake up and say, I hereby dissolve the local councils, and
because local governments are the governments that are closer to the people.
Exactly. So they must have capacity to do things that will benefit the people. When you're talking about primary school education, when you're talking about provision of basic dispensary services to the people, when you're talking about even development of agriculture, because you see that every local government land is in every local government as the primary constituency. as part of the primary constituency, it is the local governments that make up what we call the states. So if the local governments are not economically viable, just like the states too are just semi-viable right now under the current structure, it is not healthy for the system. They must look into this. Then aside from this, when you're talking about the issue of federal character, quota system and what have you, it is a kind of affirmative action, a kind of affirmative provisions in developing systems to ensure that, okay, there wouldn't be a kind of lopsided system that will favor a section against another section. Yes, it is possible that a state may have more educated people and they will have access to more opportunities than those who probably are not as much educated. But it is coming to a time that the use of the quota system is working negatively. If I have a daughter who probably scored 270 in the entrance exam to the secondary school, and there is a boy or girl from Kashina who scored probably 10, and the 10 mark scorer was given admission. The 270 scorer was not given admission on the basis that there were more people who scored higher from his, and then the quota required that they must spread it geographically. Such a daughter or son will never have any fidelity to Nigeria.
Sure.
Will think it is unfair, which is truly not unfair. Yeah. Now, how do we correct this?
It's truly not fair.
It's not fair. So we cannot characterize a particular region or a particular state or a particular section of the nation to be educationally disadvantaged. If in 1959, if in 1960, 1965, the North was educationally disadvantaged, must it be permanently disadvantaged? What is the system doing to make it advantaged? The North is not made of dullards. It's made of brilliant young boys and girls who are capable of conquering the nation, conquering the whole world, if given the opportunity. Why don't you provide the opportunity and forget about the issue of quota system and what have you? And these are things that, the Constitution must be able to, it doesn't have to be a bulky document like the Quran or the Bible, but it must, make certain provisions that would, take the interest of the masses, into consideration, and that can preserve the unity of Nigeria. Then another area is the fundamental rights aspect. You see that what is contained in Chapter 4 of the Constitution that we refer to as fundamental rights. Yes, they are fundamental rights, but how enforceable are they? If items in Chapter 2 are not justiciable, they are not enforceable, the items in Chapter 4, many of them will become meaningless too. By the time you say right to housing, there is nothing like right to housing. It is based on the capacity of the states to make provision for it. Where the state is not able to make provision for it, then based on its capacity, it could dispense with it. Now, and you're talking about right to shelter, and you're talking about right to privacy. Now, under the Constitution in Chapter 4, there is what we call the right to privacy. The implication is that if I have right to privacy, I must have a place that can be called my own, a territory, no matter how minute, that can be called my own.
That is private.
That is private, that another family cannot just pry into anyhow, But by the time I don't have a home, and I'm forced to be living under a shanty and what have you, and if the system is not making provision for all this, definitely the right to privacy becomes meaningless.
But off the top of my head, what I'm thinking is the fundamental rights that we have are not even, you try to enforce it, you're bogged down in court for so long, then how do we now make all these other ones enforceable? When the ones that are already rights are not,
exactly,
they're not being observed.
No, yes, the system has become so lopsided. When you're talking about judicial autonomy today, the president signed into law the Executive Order 10, which was meant to, enforce the what we refer to as judicial autonomy and the legislative autonomy. So if you are talking about the judiciary, it shouldn't be an appendage to another arm of government. So it shouldn't even be by executive order. People can challenge it and then want to contest the constitutionality and what have you. And lo and behold, it may happen that the judiciary will even find the executive order not to meet the constitutional requirement. But by the time it is in the Constitution, you cannot enforce a particular section of the Constitution to render another one odious or useless. No, you cannot.
The lawmakers are equally amending the Electoral Act.
Right.
I know that you have been heavily involved in electoral petitions. As someone who's been involved in electoral petitions, what area do you also think that they should focus on with regards to electoral reforms?
Thank you. This is another critical issue that is really contributing to the backwardness afflicting Nigeria. People get into offices not by democratic means these days. And this is aided by the law. If you look at the Electoral Act that we have in Nigeria today, it makes it impossible for anybody to challenge election results and be open to win or to get anomalies corrected. Why is this? The requirements of the law for a petitioner are too huge to surmount. At a time, the judiciary tried to be more conscious of this responsibility to correct the anomalies, and that is what played out in 2007 to 2010 in cases like Oshiomhole and INEC, in cases like Aregbesola and Oyinlola, and Fayemi and Oni and what have you. So for those cases, they were cases that actually tried to do electoral justice. To prove election malpractices in court, they regard these malpractices, most of them, to be criminal acts. And when you make a criminal allegation, whether in a criminal matter or in a civil suit, you are required to prove the criminal allegation beyond reasonable doubt. In many cases, offenders have gone scot-free because it is not possible for them to prove up to that standard. Most of the things
so it's a tough standard to prove.
Very tough standard to prove. So we must look at it. And now when it comes to allegations bordering on electoral misconduct, electoral malpractices, what have you, they shouldn't be placed on the same pedestal as a purely criminal act of stealing, of robbery, of killing, of manslaughter, of rape, and what have you. No, they shouldn't be on the same pedestal. That is one. Two is that.
What pedestal should they be on?
Now, in civil cases, we talk about balance of probabilities. Most of these allegations should rather be put on the balance of probabilities. If I'm able to show, maybe by some documents that look, there have been manipulations and what have you, then the court should not characterize it as a criminal thing or forgery. Shouldn't regard it as forgery, as to now require me to prove beyond reasonable doubt. That is one angle. Then the provisions in the Electoral Act today only recognize certain persons to challenge the results of a primary election. For so long as we don't discipline political parties to have what we call internal democracy, we will never produce a progressive leadership. Prior to probably about 2010 and what have you, primaries of a political party were regarded as internal affairs of a political party. If you win the primary election and I was substituted for you unlawfully, you couldn't go to court in those days. You couldn't challenge it.
Because it's a party affair.
Because it was a party affair.
Yes.
They will say, no, it is not justiciable. But later, and kudos to the legislature on this, kudos to the National Assembly on this, they now injected a provision, which is now the section 87(9), to the effect that a person who was an aspirant in a primary election could challenge the results of the primary election. Now, limiting it to somebody who participated in the primary election means that if you did not participate, you can't challenge.
You don't have any locus.
You don't have any locus.
Yes.
So you must be somebody who was fielded by a political party, but who obtained the form and participated in the process of the primary.
But isn't that fair enough?
What the political parties have now been doing.
It's when you participate.
It's when you participate
that you will have a leg to stand on.
Yes. So what they will just simply do is to say, we are doing the primary in Shugayi Street, number 5 in Shugayi, and you go and sit there expecting them maybe as early as 6 a.m., whereas they will go and conduct the primary in Maryland. So by the time you hear that they will say, we are finished. So you did not participate, whereas you spent money to buy the form. That is exactly what they did to Professor Utomi in Delta. That's what they did to Professor Utomi in Delta. In a number of other places too.
So we should reform the laws
exactly
to include those
to now allow persons who obtained forms.
Okay, who started the process somehow.
So if you know that if the political party doesn't trust you and they don't want you, it is better not to sell the form to you, because it is not mandatory to sell, it is not mandatory to buy. Isn't
that another injustice?
No, when
everybody has a right to vote and be voted for.
Everybody has a right to vote and be voted for. But look, if you want to make sure that your right to be voted for must count, you can go to another political party.
Welcome back. Reactions have not stopped trailing the 3-month extension of the expired tenure of the Inspector General of Police, Mohammed Adamu. But is the president's action legal? Lawyers appear to be divided on this. I have the views of 2 senior lawyers up next.
I think it's the right decision by Mr. President to extend the tenure, at least for the next 3 months. There's nothing unconstitutional about it. He is the Commander-in-Chief of the Armed Forces of the Federal Republic of Nigeria. Constitutionally, he has the power to do what is needful in the circumstance. Don't forget where we're coming from. This is not even the first time this is happening. I'm not saying that because others have done it, if it was illegal, it remained legal. But if you look at former presidents have done so. Former IG's tenures have been extended even beyond these 3 months. The reason is that if there are reasons where, for the interests of the state and for the public governance, for such officer to be allowed to put his house in order, especially in the circumstance of where we find ourselves in the present situation, where the present Inspector General of Police is doing all within his power for this police reform, community policing, which he initiated, others bought it, and all the governors and the other stakeholders are building on it. As a pilot scheme, would it not be prudential? Would it not be wise? Would it not be cost-effective? Would it not be for continuity to allow such a person to midwife this, accomplish this reform, and then another person can come in? Against the background of, yes, with the great respect, if you look at the pedigree of this occupier, you find that even on the international scale, if we lose him, if you look at his pedigree, the international police will take him because he has made a name there. We don't value what we have.
Well, the president does not have the power to extend the tenure of the Inspector General of Police, even by 1 minute. To talk more of extending a tenure that has already ended after 2 days of the tenure ending, and the person is no longer, in the eye of the law, a policeman. Mohammed Adamu retired on Monday, 1st February, and then the president is purporting to have extended his tenure 3 days later. That is the greatest disrespect for the Nigerian law. That is the greatest disregard for the security of this country. And that is the greatest disregard for the people of this nation. We cannot have a law enforcement agency as the police being the most unlawful agency in this country. I am disappointed that the former IGP even accepted this tenure extension. This is the man who served as vice president of Interpol for Africa. He should have been exposed enough to know how law operates, to know how the law enforcement agency called police should be. They should be an agency imbued with integrity and public trust. Now, what we are perceiving is that the president does not want to appoint a Southerner as IGP. So he's extending this tenure by 3 months to search for a Northerner he will appoint. As the police affairs, or is it police minister of police affairs said, that the president needs time to appoint. What was happening to the president all along? Didn't he know the IGP will retire on the 1st of February? He had years to select. But the Police Act has come to set a lot of hurdles to an ethnic agenda. So now they want to undermine the act by, first of all, applying a procedure that is unlawful, which is extension of tenure. And then if they succeed in doing that, they will now appoint whoever they want outside the provision of the act. That is what they are planning to do.
And on the home stretch, we bring you a recap of some of the activities from the courtrooms.
We begin with the report that the Federal High Court in Abuja has fixed the 7th of June for the arraignment of the Senate Chief Whip, Senator Orji Uzor-Kalu, who is accused of misappropriating 7.1 billion naira belonging to Abia State government. Justice Inyang Ekwo adjourned the matter following an oral application made by the Economic and Financial Crimes Commission that a letter has been written to the Chief Judge of the Federal High Court requesting the trial to be conducted in Lagos. While the EFCC says it is still awaiting the response of the Chief Judge, the defendants are insisting that the proper place for the trial is Umuahia in Abia State, where the offences were allegedly committed. Still on allegations of misappropriation of funds, the EFCC has alerted the Federal High Court in Abuja that Mr. Faisal Maina, son of the former chairman of the defunct Pension Reform Task Team, Abdul Rashid Maina, is on the run to the United States of America. At the resumed trial of the case, the lawyer to the anti-graft agency, Mr. Muhammad Abubakar, told the trial judge, Justice Okonaban, that from the information at the disposal of the commission, Faisal Maina sneaked to the USA through the Republic of Niger, despite the fact that his Nigerian and American passports are with the registry of the courts. The Commercial Director of Process and Industrialization Development, PNID, Mr. Mohammed Kachazi, has been arraigned alongside his company, Kore Holdings Limited, on an 8-count charge bordering on money laundering. The EFCC, who arraigned him, says that if the PNID's $9.6 billion judgment against Nigeria had succeeded, he stood to benefit about $300 million. He pleaded not guilty. Justice Folashade Giwa Ogubanjo admitted Kuchazi to bail with 2 sureties in like sum who must be directors in the civil service and who must have landed property in Abuja. The judge also held that before Kuchazi travels outside the shores of the country for medical attention, he must notify the court through a written letter. Another Federal High Court in Abuja has awarded 150,000 naira cost against Olawale Bakari, the co-defendant of Omoyele Sowore, for his absence in court. The two are being prosecuted for treasonable felony by the Attorney General of the Federation's office. Mr. Sowore, on his part, arrived at the proceedings late, but early enough to avert being slammed with a similar fine. Justice Ijoma Ojukwu has expressed her displeasure with the defense towards the proceedings. The judge said she will not condone any action that could delay the trial. And we round off with the report that the ECOWAS Court of Justice Abuja has fixed April 22 for judgment in the case brought by Social Economic Rights and Accountability Project SARAP against the federal government, seeking justice and accountability for the authorities' failure to prevent, account for, and investigate killings, raping, maiming of Nigerians and other residents, and destruction of property across the country by herdsmen and other unknown perpetrators. The court fixed a date for judgment after hearing arguments from solicitor to SARAP, Femi Falana, SAN, and the government's lawyer, Mr. Adebayo Ogundele. In the suit, SERAP is seeking an order directing the defendant to investigate all cases of unlawful killings and pay adequate money compensation of 50 million naira to each of the defendants.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I am Shola Shieli. Thank you very much for watching and see you next week.